over to Philip, I think, to kick us off.
Thank you very much indeed for that fantastic introduction. Yes, as you mentioned, we are, Michelle and I have acted for the NUS, for student unions across the UK for many years now, doing a whole range of all sorts of employment issues. And we're joined today by our new colleague, Sarah, who is joining us and working with the sector and getting a feel for some of the special and unique issues that you have in student unions. In terms of our employment law update, we've tried to choose cases which we feel are particularly relevant to student unions. So the kind of things that we see cropping up fairly regularly, and hopefully we'll chime with you as matters that are the kind of things that you will come across in real life. So we will press on. Please do feel free to ask us questions as we are going along. If they're tricky, I'll get Michelle to answer them. If they're nice and easy, I might answer them. We'll be able to pick them up as we're going along, or there'll be, fingers crossed, there'll be time at the end and we can do them then as well. So the first part of the section we wanted to cover is discrimination. And it's fair to say that some of these discrimination cases have been sort of particularly, I think, interesting, the way that they're currently evolving. And there are a number of very interesting cases which have sort of kicked off in recent times. So if we look at the first case.
Yes, thank you, Philip. Okay, so the first case we're going to look at, this is a decision from December of last year, 2019. And the Employment Tribunal here held that a blanket no beards policy indirectly discriminated against a Sikh job applicant. Now, briefly, the facts of this case: Mr. Sethi, the applicant, he applied to work for an agency, and that agency supplies hospitality staff into hotels, mainly five-star hotels. And the agency had a policy that the men needed to be clean shaven. And the agency told Mr. Sethi that it's a requirement of their clients, a requirement of the hotels, and that it was for health and safety reasons and for hygiene reasons. Now, as a Sikh, Mr. Sethi strictly adhered to the principle that he should not cut his hair at all. So he said that this policy was indirectly discriminating against him because of his religion. And for anybody that's not particularly familiar, indirect discrimination essentially means that an employer is applying a provision, criterion, or practice, which in this case was a policy, that doesn't necessarily intend to treat anybody less favourably, but it has the effect of disadvantaging a group of people that have a protected characteristic, in this case, religion. And the tribunal agreed. They said this no beards requirement, it did indirectly discriminate against Sikhs generally, and Mr. Sethi in particular. And there is a defence available to indirect discrimination. It can be justified if there is a legitimate business reason, essentially, and that it's proportionate. But in this case, the tribunal said that no, actually this policy can't be justified. And what they looked at was they determined the aim of this policy, the business reason for this policy, it's not health and safety reasons, because the written policy itself said it was for maintaining high standards of personal appearance. Now on maintaining a high level of personal appearance, the tribunal said, well, that can in itself be a legitimate business reason, but here it's not proportionate because this policy had a very significant impact on Sikhs. And this aim, this reason, it could be achieved by less intrusive means. For example, by requiring Sikhs to wear their beards in a tidy fashion, for example. Now, the agency put forward the agency's primary defence, their primary legitimate business reason, they said, was to comply with their clients' requirements. The hotels require them to be clean shaven. And again, the tribunal said, okay, well, that can be a legitimate business reason, but here it's still not proportionate. And what they looked at, they said there was no evidence that this agency had approached the hotels and asked if they would make any exceptions for Sikhs. And plus the fact, not all of the clients, not all of the hotels actually had this blanket policy. So the tribunal said this policy, it cannot be justified. And so Mr. Sethi's claim was successful. Now, what does this mean? What does this mean for employers and for student unions? Well, where you do have a policy or a practice that does put a group with a certain protected characteristic at a disadvantage, there are circumstances when it can be justified. It can be a legitimate business reason that's proportionate, a proportionate means of achieving that. But you must be able to show that you have fully considered all of the ways in which you can still meet that aim, you can still meet that business reason in a non-discriminatory way by exploring all of the options instead of applying a blanket policy as they did here, which was then found to be indirectly discriminatory.
Thank you, Sarah. So a couple of cases here which I think illustrate two things: a growing trend, and it's a trend where you get what you might regard as a sort of a conflict, a tension between one protected right and another protected right, and a tension as to, well, who wins? How does that balance work? And then it also reflects a trend where we're seeing an increased number of cases involving the issue of transgender rights. So this is something which I have seen throughout my career, the way it's evolved, and where we are now with the law is it's very much the there seems to be a number of test cases where people are putting points forward in order to test the boundaries of the law, and these first two represent examples of both those sort of trends. So the first case is very interesting, and some of you might remember there were cases a few years ago involving the registrars of marriages, where they were refusing to carry out same-sex marriages, technically same-sex civil partnerships, on the grounds of their religious belief. And this is a similar trend to that sort of case. It involves a doctor. The doctor was a Christian. He was pretty much a fundamentalist Christian. His ET1, his claim form, quotes Genesis as part of his defense, which doesn't happen very often. And he basically said that he was not prepared to use the chosen pronoun of transgender patients. He would refer to them by their birth pronoun. And he said, and he relied on Genesis to justify that stance, and said that this is my Christian belief. He was dismissed. He says that's discriminatory. You're discriminated against me on the grounds of my Christian belief. So again, a classic tension there to say, well, hang on, whose protected rights should win out? And the balance, and this has been a long-standing trend in these cases, is that the courts and the tribunals have always been very clear. Look, one right doesn't trump another right. They should all be treated with equal respect. So the Christian doctor cannot rely on his Christian beliefs to allow him to ignore the legitimate beliefs of the transgender patient. So he lost his case. Very sort of similar sort of issue, provoked a little bit of a storm of controversy, this one, in the Forsater case, where basically this was a researcher who put forward an argument that it was, in her considered opinion, it was frankly impossible. It was biologically impossible for somebody to change their gender, and she ran that argument. It was run as a sort of it attracted quite a lot of publicity, and many of you will be very familiar with some of the public statements for and against this argument, where you get certainly some very sort of vocal groups on both sides of the argument. What the law decided, again, very similar outcome, to say, well, look, your right, your right here that does not trump the other person's right. So so she's entitled to have this belief. That's perfectly reasonable for her to have a belief in a free society. She can believe it if she wants. However, her absolutist, and it's quite a strongly worded expression, her absolutist beliefs are not worthy of respect in a democratic society, i.e. that they could not be used to take priority over the rights of the transgender individual. So quite an important distinction. These are cases that are likely to evolve on time. These are watch those cases type things. I know that many student unions have, have issues where they consider the whole debate about the use of pronouns, the correct use of pronouns, whether people should be given the choice, whether it should be identified which a pronoun that you wish to be referred to on your ID cards and your emails, etc. And that could be, I can see that there's a trend in favour of that sort of approach, but it's still quite, contentious. Some people, are not, would find the balance somewhere else. But it's certainly interesting the way that the law is evolving in that way. The next few cases, including this first one on the last one on my slide, is all to do with the other side of the coin. So this whole religious belief also covers a thing called philosophical belief. So it's religious or philosophical belief. And the question is well, what does that mean? Religious belief I can sort of understand, but philosophical belief, where are the boundaries? What's covered and what's not covered? And this was an individual who basically believed in copyright law, intellectual property law. He was a great believer in his personal rights to protect his own intellectual property. That wasn't good enough, so that case failed. And I know Sarah's going to look at another couple of examples on her slide.
Yes, absolutely. Yeah, we have two very interesting cases here on whether vegetarianism and veganism are beliefs for the purposes of the Equality Act. So attracting that protection for people being discriminated as a result of that belief. And vegetarianism was considered first. So the Conisbee case on the screen here, this was in September of last year. And the tribunal said that vegetarianism is not a protected belief. Now, there's a whole range of factors sort of in the legal test, which I won't go into detail about, but the main reason why the tribunal said it's not a protected belief is they said vegetarianism is more of a lifestyle choice. They said people are vegetarian for many different reasons, whether that might be for health or for diet or animal cruelty, etc. There's a whole range of reasons why people do it. And because of that, vegetarianism doesn't reach this necessary level of cogency, of cohesion and importance that is required in order to be a protected belief. And it's the first decision we've had on vegetarianism. And because it was only a first instance decision, it's not actually binding on all other tribunals. So it's very much open for another judge or another tribunal to challenge this and come to a different view. But it's certainly an area that's going to keep evolving. And a few months later, actually, the Kasimit Jana case, this was in January of this year, and it was actually the same judge as the Conisbee case, but in a different set of circumstances. And he looked at ethical veganism, and they said, actually, ethical veganism is a philosophical belief, so it is capable of protection. And the main reason for that, the tribunal said, was because this belief that it's morally wrong or unethical to harm animals for food, for clothing, or for any other purpose, they said that is more than just a diet, that's more than just an opinion. So the tribunal said that ethical veganism, that does have the level of cogency, so it is capable of protection under the Equality Act. So they're both very much developing areas, and both veganism and vegetarianism is attracting more attention. People are adopting it more nowadays. It's very relevant in today's society. So it's definitely an area to keep your eye on. And Philip, I think you've been involved in a particularly interesting case looking at Brexit.
So one of the cases, not on the slide, it's a bit of an older case, but there was an example where somebody was able to argue that a belief in Scottish independence could potentially be a philosophical belief that could potentially justify protection. And both Michelle and I were involved in a case where somebody who relying on that Scottish independence case ran exactly the same argument, but said it was Brexit. It was my philosophical belief of the advantages of Brexit that should have special protection. And you can imagine this was an individual who was dismissed for poor performance. He says the real reason why I was dismissed was because my boss thought I was a fool for voting in favour of Brexit. And that's a philosophical belief and therefore merits extra protection. And it does actually demonstrate the difficulty with this whole philosophical belief. When the religious discrimination was originally brought in, the wording referred to religious belief or similar philosophical belief, but they crossed out, they amended it, they crossed out the word similar. So it's now philosophical belief. And that does actually, there's a whole 1,001 things you can think of. You can think, well, maybe that's would qualify as a philosophical belief, a bit like the sort of the veganism example which Sarah mentioned. Now, the veganism example was interesting because both sides agreed that veganism was a philosophical belief. So the employer agreed too. It just simply said, but we didn't discriminate against the person on that grounds. So it was a case where the tribunal was being argued from both sides in the same direction. In my case, we were defending this and saying, well, no, Brexit can't be. But I have to say, you can imagine a situation if you had an individual and it was more than just a sort of general preference, but somebody who was, absolutely adamant that Brexit, or indeed anti-Brexit, absolutely adamant, then you could conceive that might be a philosophical belief. If you're the kind of person who's prepared to stand outside of Parliament, for months and months with a loudspeaker, you may have an argument to say that's a philosophical belief, way beyond a lifestyle choice or some general political opinion. Now, in my case, very fortunately, it went away. So we never got a decision, which is probably a good thing. But it does illustrate that the scope of what could be covered under this heading.
And Philip, we've just had a question pop up around positive discrimination, actually, and I don't think that's something we specifically cover unless one of the cases does. But somebody's asked and said they've recently seen the introduction of must have lived experience of a particular protected characteristic as an essential criteria in a person specification or in a job application, and how this sits around positive discrimination.
So. Well, this is actually, I appreciate, quite a delicate subject, and actually, it's particularly it's an area which I think student unions have a delicate balance to walk between what the law says and perhaps what some people would like the law to say. Now, I'm a lawyer, so I can only speak from whether it's right and wrong. This is what the law says. So the law says, with one or two very, very minor exceptions, positive discrimination is just as bad as negative discrimination. So many years ago, I had an example of a white male firefighter who was denied a job because they wanted to give preference to female applicants and applicants who were non-white. We won that case. He succeeded. That was regarded as being just as bad as having as saying we don't want you because you're a woman, we don't want you because you're non-white. So, and that frankly is what the law of the land says. Now, and I appreciate that there's a delicate balance to be struck here because I've seen the arguments that the law doesn't go far enough, but nonetheless, that is what the law says. There are some minor exceptions. Exception number one is where you are allowed to do special training days, to advertise in particular sections. Well, we used to say newspapers and magazines, but now on social media, which are designed to focus on particular minorities, where you're looking to increase your the scope of your applicants. That's definitely possible, and there's some special exceptions which allow you to do that. In terms of a job application, then there is an exception which is called a genuine occupational requirement. So that there is a thing where it is legitimate, where you can say it's a genuine occupational requirement of this role that you need to be from a particular background, gender, race. So it's a real thing. I wouldn't get carried away with it just because it's a real thing. It really is an exceptional circumstances only. But a good example, perhaps, is you do get examples where you might get a charity, where the charity is representative of a particular, particular sector area, where as part of its, they will, as part of its ethos, they will say, we want somebody who is representative of the community that we're seeking to look after. And so we might want a woman for this charity. We might want a gay person for this charity as our lead figure, as our CEO or our chairman or whatever it might be. So that's where you typically get that argument. So it's definitely possible, but it's not something to be free and easy about. And it's I agree, there is a growth in doing this, but you do need to be prepared to stand up and defend yourself. If you put it on your advert, it's almost inevitable that somebody will sue you. So you do need to be able to explain why you think, oh no, we definitely fall within this exception. Sometimes you hear people talk about other exceptions, but those are exceptions which used to apply under the old Race Relations Act and the Sexual Discriminations Act. And unless you're as old as me, you won't remember those, and they're different, they're gone. So you can't quote some of the old offences don't exist anymore. We have to rely on what exists in the Equality Act.
Okay, thank you, Philip. Right, so we're going to move on to developments in disability discrimination in particular. And the case you'll see on your slides now, this is a case from November of last year and concerns reasonable adjustments. So just as a reminder for anyone not familiar, an employer has a duty to make reasonable adjustments in certain circumstances where a disabled person is put at a substantial disadvantage. So for example, that might be because of a physical feature of the building or a policy or some other provision, criterion or practice. And this case is interesting because it concerns the removal of reasonable adjustments that have been in place historically. So here we have an employer, they'd made reasonable adjustments to their sickness absence management policy. And the policy, like most do, had trigger points for absence management of 3 absences in a 12-month rolling period. And it adjusted that to 5 absences in a 12-month rolling period for a disabled employee that had ME, so chronic fatigue, and was prone to having more absences than most. So that adjustment continued. It continued for 4 years. It was working well. It was helping to alleviate that disadvantage. But then the employer decided to remove it, and it went back down to this 3 absence in a 12-month period. And the employer, they made other adjustments at the same time. So they introduced flexible working and reduced hours, etc. But ultimately, this employee, they couldn't meet this attendance requirements. They hit that 3 absence trigger, and the employer invoked the absence management policy and eventually dismissed them. Now, she brought claims, a few different claims against the employer, but on the subject of reasonable adjustments in particular, which is where we're interested here, the tribunal said that employers don't necessarily have to continue with the same reasonable adjustments forever, indefinitely, because there may come a time when that adjustment ceases to be reasonable anymore. There might be better alternatives, or it might not be practical anymore for many different reasons. But what they said was, in removing any reasonable adjustment, the employer should be able to show that there has been some sort of change in the circumstances that now renders this adjustment unreasonable. And here the employer couldn't do that. Tribunal said that although they've made other adjustments, that wasn't enough. It's not enough to comply with their duty, because the adapted management procedure before, the adjustment to 5 absences, that was a more effective adjustment. And tribunal said that reasonably that could have continued. So there wasn't a good enough reason for withdrawing that. So it's an interesting case because it's a reminder in any event that as employers, you must be considering what adjustments you should make to your absence management procedures for disabled employees. But what it also tells us, this case as well, is that when considering removing any adjustments as an employer, you must carry out a proper analysis of why this adjustment is no longer reasonable, why you want to remove it. Have you considered all the alternatives to achieve that in a less discriminatory way? And have you really considered, actually, does that reasonable adjustment need removing at all? So it's just a reminder when dealing with reasonable adjustments that, you know, you can't just remove them just for the sake of it, just because you think something else is going to work instead. Have you really looked at that? Because in this case, the employer hadn't, and the employee succeeded with their claims.
Thank you very much, Sarah. So interesting case here. This is something which I have seen crop up with student unions, you know, quite a lot, really. It's something which crops up. So it's a bit of a complicated case, so I'm going to strip it right down. So really, this is the situation here, is you have an employee who's on long-term sick. And the reason why they're on long-term sick is because they say they've been subject to bullying, harassment, and they're suffering from stress, and they're off on long-term sick, and eventually they get dismissed because of that sickness. And the question is that an unfair dismissal? Is that unlawful discrimination? And the two things I would say that come out of this case is, well, firstly, if it is discriminatory, if the reason why I've dismissed somebody is discriminatory, it's almost guaranteed to be an unfair dismissal. So you get caught for both. However, for obvious reasons, that doesn't apply the other way around. So just because something is unfair, it does not automatically amount to unlawful discrimination. It doesn't automatically count. So, and you can defend that, the alleged discrimination on, on normal legal principles. Basically, being unfair is not the same as discriminated against somebody. That I think is one of the points. The other one, and it picks up actually something that Sarah was saying, is these are typically indirect discrimination cases. So it's basically about, well, the reason why this person was dismissed was because they'd been on long-term sick leave. Nothing to do with the underlying disability, nothing to do with the fact they've suffered from stress, nothing to do with the rights and wrongs of the complaints of bullying and harassment. They're just not being able to do their job because they're too ill. So that's the reason. Now, therefore, it's not direct discrimination, but it might be indirect discrimination. It might be, even though it looks neutral, it might have this adverse impact on a particular group of people. And in this case, the appeal tribunal says that the original tribunal didn't do its job properly, didn't really consider this properly. And again, Sarah touched on this in a different context, but what does that mean in reality? What are you supposed to prove? Well, it's called justification. It's got a specific legal test. But point number one is, what is your legitimate business reason for doing what you're doing? So if I am dismissing somebody because they've been on long-term sick, well, why? Why am I doing that? Now, normally, that's not too hard to prove. That's literally saying, well, I've got a legitimate business reason here because I need, that role needs to be filled on a permanent basis. I can't hold it open any longer. So normally that's not too bad. But the second part of the equation is, and have you acted in a proportionate manner? And that proportionate manner, that's always the legal argument. And what does that mean, proportionate manner? Well, actually, that means, well, have whatever I've done, did it actually contribute? Did it achieve or contribute to my legitimate aim? So by dismissing this individual, have I actually done something which assists my legitimate aim of finding another person to fill that role? Well, you'd say, oh, yes, it has. That's legitimate. The second one is there some better way of achieving what I wanted to achieve, which is less discriminatory? That's normally the legal battleground. Normally, clever lawyers, they look to suggest all sorts of alternative options you could have adopted. If only you'd done this, everything would have been fine. In this particular case, this individual, as far as I can tell, was never going to come back to work. So it's difficult to know what alternative there could have been in order to get her back to work. And then the final point is to do a balancing exercise. Is the impact on the individual, the adverse impact on the individual, is that outweighed by the positive impact on the organization and upon other individuals within the organization? So it's a bit of a balancing act. So it's slightly subtle, all those different things you have to think about. But you can see that very often that in a situation like this, it's usually possible to justify dismissing somebody where they have been sick for an awful long time, even if the catalyst for them being off sick, you might say, but that was discriminatory in the first place.
Okay, we're going to move on to dealing with dismissals, and the case on the next slide here. This relates to the use of anonymous witnesses, which is always a very difficult issue to navigate, because often your witness evidence is absolutely crucial if you're dealing with a grievance or a misconduct issue. And just very briefly, the facts of this case: there was the claimant worked for a housing association, and one of the tenants of the housing association alleged that they'd made homophobic comments, and that employee was ultimately dismissed. And the tenant, they were interviewed by 2 managers anonymously at the tenant's request, but they weren't interviewed again. They weren't able to then be interviewed again by the decision makers who actually determined whether the claimant would be dismissed or not. So they brought an unfair dismissal claim, and in the first instance, the tribunal agreed. They said the dismissal was unfair, and there were a few reasons mixed in there, but they did also say that it was unreasonable to rely on that anonymous account of that tenant. And the case was appealed by the employer, so it went up 1 level to the Employment Appeal Tribunal, who said that the judge in that case, they should have demonstrated logical and substantial grounds for reaching the conclusion that the anonymous statement couldn't be relied upon. And they said that the judge hadn't done that in this case. So it actually was sent back to a different tribunal to be heard all over again, absolutely afresh. And there were a few more nuances in that case that I won't go into detail on, but it's interesting because the points that I've identified are interesting because it emphasizes that it isn't necessarily the end of the world if you have a witness that doesn't want to be identified for good reason. And it's by no means a green light to be relying on anonymous witnesses, certainly when dismissing employees, but it's a reminder to sort of go through this checklist if you are dealing with anonymous witnesses. So can you investigate the reasons and the motive behind their request to remain anonymous? Can you investigate the credibility of the witness? Can you corroborate their evidence if possible? And can you need to determine the weight of that statement. So how fatal to the case is this anonymous person's statement? Because we know from this case and from cases that have come previously as well, that the tribunal will really scrutinise the reasonableness of the employer in relying on anonymous witness evidence. So it's another balancing exercise that needs to be carried out. So you're balancing the need between the witness's request to remain anonymous and the need of the employee to know the details of the case that's being put against them. But the comments of the Employment Appeal Tribunal, they are, to a certain extent, some comfort for employers. But it's more of a reminder of the need to really go through this checklist and really assess the reasonableness of relying on anonymous witness statements, because it is a particularly tricky area.
On that, Sarah, this is an area I've had a number of cases over the years, and it's something I feel quite strongly about. As a lawyer, your ideal witness is the one who's prepared to sign a piece of paper and stand up in a tribunal and say, yes, I saw this, yes, he said that. That's your ideal witness. However, there's a whole sort of spectrum of witnesses, and it's very common to get anonymous statements. And in a student union context, you sometimes get this where it may be a non-employee. The statement might be given by a student or a former student or something like that, where they want to have their say, but they don't want to be embroiled in an internal matter either. So you sometimes get things like that. And really, the way to approach this is to say, well, I don't ignore an anonymous statement, but I am supposed to assess the credibility of that statement. Do I think it's valid? Is it basically somebody just who's got an axe to grind, who's having a pop at somebody, and it's all speculative? Or is there more here than meets the eye? But I've certainly used anonymous witness statements very effectively in cases in the past to justify dismissals in appropriate cases. So it's definitely a very useful reminder, I think, this case, that it's not actually, you don't have to get a signed statement from everybody before you can take action in an appropriate case.
Yeah, thank you, Philip. Okay, we're going to move on to some interesting cases on whistleblowing next. So the case that you'll see on the slides now, this is a case from December of last year. And just as a gentle reminder, if dismissing an employee and if the main reason for their dismissal is the fact that they have made a protected disclosure, i.e. that they've blown the whistle, then that dismissal will be automatically unfair. And I won't go into the entire background of this case, but it went all the way to the top. It went all the way to the Supreme Court. And what the Supreme Court said was that the employee in this case, they were dismissed as a result of blowing the whistle, even though the person who actually made the decision to dismiss them was unaware of that, which is what makes it so unusual. And what the Supreme Court said was that actually the employee's line manager in this case, they had made the decision that they wanted to dismiss this employee because she'd blown the whistle. But the line manager then kind of cloaked the reason for her dismissal in allegations of poor performance instead. And those allegations of poor performance, they were picked up by somebody else, an investigating officer, who had no idea of the background, of the full knowledge of the whistleblowing details, but who they picked up these poor performance allegations, assessed them, and ultimately decided to dismiss the employee for poor performance. But what the Supreme Court said was that the real reason here actually was the whistleblowing. And this decision is particularly interesting for two reasons, really. I mean, firstly, where you do have a whistleblowing issue, where you are dismissing someone, but there is a whistleblowing issue. And whereas you might think you can rely on the fact that, well, the person who actually made the decision to dismiss them didn't know about the whistleblowing, they didn't know about the complaint, or, you know, they weren't involved in it at all, it was completely far removed. Well, what this case is telling us is that actually we should just consider that further first. Could there really be any cloaking, any manipulation, as the Supreme Court described it, by someone at a more senior level? And the second reason why this case is really interesting is because it could have, and the Supreme Court did say this, it could have some wider implications for ordinary unfair dismissal cases, so not just whistleblowing ones. But they will be rare. It's not anything to be, you know, overly panicked about, because in most cases, in ordinary unfair dismissal cases, it will still only be the reasons of the decision maker that will be the most relevant to an unfair dismissal case. And so instances of decisions to dismiss that have been taken in good faith, but actually for a wrong reason, because somebody else has dishonestly constructed a different reason, they are going to be rare circumstances. And it would only apply if that manipulation was coming from somebody in the hierarchy above the employee, so the line manager, for example. But whistleblowing issues, they're always particularly tricky, and, you know, as I'm sure everybody's aware, you know, it's always important to really look when you're dismissing somebody. Is there any whistleblowing issues there? Have they made any disclosures? Because an automatic unfair dismissal case for whistleblowing, you don't need 2 years service for that. They can make that claim at any time. So it's always important to really look around, and are there any other circumstances that we need to be aware of? So this case is just a highlight of that particular issue.
Thank you, Sarah. Oh gosh, the Riley case is a sort of a fabulous example how complicated these things sometimes get. I was also involved in another appeal case a few years ago, which had some similar themes. The thing to remember about whistleblowing is definitely a growth area. It seems exceptionally common. Almost any claim you get these days seems to have some sort of whistleblowing thing thrown in. It seems to be becoming particularly prevalent, quite common for student unions to see this thrown into the mix as well. And the thing about it is there's two elements to the legal test. A, did the person blow the whistle? Have they said something which counts as blowing the whistle? Merely complaining about stuff, not good enough. You need to basically disclose information which tends to demonstrate some legal wrongdoing of some sort, which is in the public interest. It's a fairly subjective test, so it's based on the individual's reasonable belief in making that disclosure. They can be wrong in making that disclosure, but did they disclose something? So that's part one. Part two, and did you pick on them? Did you subject them to a detriment? Did you sack them because they blew the whistle? So it's causation. Sometimes you get these cases, people just assert, well, I blew the whistle and then something bad happened to me. I was made redundant. And it's like, yes, that's true, but they aren't linked. They are two separate things. They have to be linked. And this case sort of beautifully illustrates the typical issues you get in these whistleblowing cases. So this is something which the individual concerned who basically ends up in a row with various members of staff and is described by the tribunal as being rude, angry, and frustrated. So voices a whole series of statements in a very rude, angry and frustrated manner to their colleagues, bosses, in a bit of a heated row. The claimant, the individual, their cases, in amongst that rant, in amongst all those rude comments, I explained to them that if this is a financial services business, it was all about mortgages. I made allegations that they were using inexperienced staff to sell mortgages, that they were selling staff to people who had poor credit histories, that they were in breach of FCA regulations and the FCA code of practice. So the claimant says, I'd made a whistleblowing disclosure. That's all legal breaches. It's all in the public interest. The fact that I happen to say it shouting at you is irrelevant. The manner in which I said that is irrelevant. This individual gets sacked. Or their contract gets terminated. The employer basically says, look, this, I guess reports about how rude and horrible they were, and so they get dismissed. So the tribunal basically believe the company, believe the respondent, but it goes to so the claimant appeals, so it goes to the Employment Appeals Tribunal, and the point here is that where somebody blows the whistle, if they do it in a way which is perhaps aggressive or in circumstances that you might say is normally unacceptable, you have to count to 10 and say, well, no, that still counts as blowing the whistle. So the EAT says, look, in this case, you could not separate what you might, the actual disclosure, the whistleblowing, from the manner in which the whistleblowing was disclosed. You couldn't split those two things up. They were the same thing. So because of that, if you then dismiss them because of that behavior, that still counts as whistleblowing. And it's quite interesting. The case I was involved in had a very sort of similar point, where it was involved a lawyer, and the lawyer was a regulatory lawyer, and the argument was they weren't a very good regulatory lawyer. Being a regulatory lawyer, nearly everything they said was whistleblowing. It was related to some related to some legal breach or the other. But the employer's position was, but they're not very good at their job. We want to sack them because they're not very good. And that claim worked. They were able to dismiss them because they were able to say there's a difference between your sort of comments about your whistleblowing, if you like, but also the fact that you're not actually a very good lawyer. That's a legitimate reason to dismiss somebody. But in this particular case, it was so so complicated and intertwined that the fact that they had said these points in a forceful way, it still counted as whistleblowing. This is very similar to trade union cases. There's like a very old trade union case where if your trade union representative, your employee, who's a shop steward, if they make their points with their trade union hat on and they shout at you and they bang the table, then you have to count to 10 and say, well, they're entitled to do that. If doing their regular job as an employee, they were to shout and swear at you and bang the table, you might say, well, that's very rude and insubordinate. I'm going to discipline them for that. And with as a regular employee, that might be right. But with their shop steward hat on, they're allowed to make their trade union points in an assertive and forceful manner. The manager has to count to 10 if that happens. So it's a bit like that. There's a bit of a twist in this case, though, because despite more or less finding in the claimant's favor, yes, you were dismissed for these matters, the EAT then turned around and said, but the stuff you mentioned wasn't whistleblowing at all. So these various things that you said during this conversation didn't count as whistleblowing. So even though you were dismissed because of these comments, they weren't whistleblowing, and therefore your employer hasn't done anything wrong. So actually, the claimant won on one point, but lost the war because the tribunal found on another case point against them. But there you go.
Thank you, Philip. Now, I think I'm just conscious of time, and these slides will be available for people to have a look at afterwards. And on this slide you'll see here, we've put a couple of cases to look out for. But given that we don't want to run out of time, I think we'll just move on, if that's okay with you, Philip, just to the final section.
I would just, I think we just, on the previous slide, I just wanted to highlight this very last case. This is something which the NUS have asked us in the past to do updates for student unions on, because it's something which is, I know, particularly challenging, and it's all about how to calculate holiday pay for particularly student staff. So people who work maybe part of the year, people who work maybe on a flexible contract, maybe they are casual staff, so and they come and go, and the very short point about this particular case is that many student unions, in fact, many companies, something to do with student unions, many companies for that sort of person have been applying this sort of rule of thumb formula where you basically say, well, 5.6 weeks holiday pay is equivalent to about 12.06% of your hourly rate. Therefore, I'll pay you 12.06%. There you go, there's your holiday pay, jobs are good and problem solved. And it's in lots of the commentary refers to this 12.06%. It's regularly referred to in precedents, so it's very common for people to do it. This case is a reminder that that 12.06% is just made up. There's no law behind that. The law has a legal test. The legal test says I'm supposed to calculate people's holiday pay by applying a formula. If I apply the formula and it turns out they're due more than 12.06%, I owe them the balance. And it's as simple as that. And in this case, is a good reminder. It was, we're looking forward to it going to the Court of Appeal, or I should say, going to appeal. But it's definitely something I know student unions have been found challenging, because it's definitely something which very often student staff are on these contracts and they're often paid rolled up holiday pay where you're paying as you go. Rolled up holiday pay, it's not strictly correct. However, usually it doesn't matter, because usually you get credit for the money you pay. So even if I've done it wrong, the employee's not, or the worker hasn't lost out, therefore no harm done. You know, it's fine in practice. But this case is a reminder that you can, you know, nearly by having a flat percentage, it doesn't always work. The numbers in particular tend to be quite erratic, where you get somebody coming and going. If somebody's there for a full year and works a few hours every week, the 12.06% normally works out pretty well. But if somebody's coming and going, working random hours, working only part of a year, actually it can be sort of 18%. Okay, there you go, Sarah. Sorry, I'll move on. I'll skip on there. I think we've got, we've included a few slides in the next part of the section. And I'm not going to sit here just reading out the slides and boring you all rigid. But I thought I would summarize them. These are all things that, you know, student unions, like all of us, have been you know, dealing with the challenges of the coronavirus and the restrictions. And many universities are facing severe issues because of the restrictions they're facing. And student unions obviously are also facing exactly the same sort of issues. The Chancellor has announced a whole series of measures as to what we can, to assist us. So we sort of mentioned some of these things on the slides. To be fair, we don't have the detail, as ever. We don't have the detail. These are just headline figures in press releases which the government have issued, which are quite helpful. But until you see the details, it's impossible to say. So I wasn't going to bore you with those, but they are on the slides. One thing I would mention, I know a number of student unions have relied on the furlough scheme, perfectly lawful, perfectly legitimate. It is fair to say that the furlough scheme has been a bit of a legal Wild West. We don't know how the rules have evolved, they've changed, they've gone back and forth. It's been a lot of crisis management in terms of dealing with it. And lots of people, you know, in good faith have made their claims for furlough pay, and you know, we've dealt with that. It's fair to say now that we're coming out of the furlough situation, HMRC have made it absolutely clear that they're going to be scrutinising this and making sure everyone's claimed properly. So during the actual crisis itself, during the main lockdown, HMRC seemed uncharacteristically liberal in giving money away and letting people take money on furlough. However, they're back to their far more traditional approach to say they're really going to be scrutinizing this stuff. So it's fair to say that I would, you need to work on the basis, if you have relied on the scheme, it would not be at all surprising if you get audited over the next 2 to 3 years. There is an ability to, when you're going through your own records and you're doing your own auditing, that you correct mistakes. That if you say, you know what, we've overclaimed here, we ought to pay that money back, there is a position to do that. And that's important to remember. Far better, if you spot an obvious mistake, far better to correct it than wait until you're audited and get fined and penalised. Albeit HMRC have said they're not going to be adopting a sort of daft approach to this, provided you follow the guidance. They will be, they will be approaching a sense, in their terms, a common sense approach. But common sense for HMRC is not the same as common sense for everybody else. So I'm sure they are usually pretty assertive about these things. So that's what we've got to look forward to, probably over the next 2 to 3 years, as they get round to everybody and start auditing people's tax records. I don't think then, I wasn't going to mention any of the other things, although on the slides we do talk about the various things. I don't know, Michelle, do we have any questions that people have asked before we wrap up?
No, we haven't got any. So we've dealt with the questions that came up in the discrimination section. We haven't got any open questions at the minute. Obviously, if anybody does have any questions, we've still got a few minutes if anybody wants to ask anything either about any of the cases that they've talked about or anything about the current COVID-19 issues.
Yeah, it is interesting. I think in terms of sort of student unions, it's a particular challenge. I think some of the issues that we've seen, we were discussing these in our session this morning on redundancy, which are quite relevant, where you get things like redundancy exercises and the interrelation between your sort of core employed staff and student staff. These are all issues which I think student unions are likely to have to sort of deal with, as we go forward into the next sort of next year. And we are in this somewhat limbo position where many universities are operating special basically special frameworks as to how students are will be able to carry out their studies, which is going to have a direct impact on student unions. It's going to be a very uncertain time. You can read in the press a number of universities are financially really in big trouble, and so it is a somewhat difficult time for the sector generally.
And just to let everybody know, our contact details are on the last slide there. So if we haven't covered something you wanted us to cover, or if you've got any questions, just please get in touch.
Oh, we've got time for the last question. We've got 2 minutes.
Yes, hopefully.
I've been previously asked the exact same question for a student union, and this is whether you can have a two pay scales, your pay scale for your core staff and your pay scale for, well, it could be a new staff, it could be a student staff. And the short answer is yes, you can do it. There's nothing called fair pay. So you can have different grades of staff, or different staff during different times paid at different rates. What you can't do is you can't have unequal pay. You can't have differences due to gender. You can't have differences due to any sort of unlawful reason like that.
Perfect. Good quick answer.
Well done.
I did try. Okay, in that case, I will thank you all very much.
Thanks, everyone. Thanks to
you.
Philip, Sarah, and Michelle. As always, a really interesting talk from you about what's going on legally. If anyone wants to catch up on any of that, our video will be on replay within the next 24 hours. So a real good session, and do make sure you share it around your HR departments and your senior management teams. Brilliant. Thanks, everyone.
Thank
and
you
have a
very
good
much.
rest of the
Thank you very
conference.
much.
Bye-bye.
Thank you.
Fab, thank you very much.